So under 803.5, if a witness who's now on the stand used to remember something, and at the time that witness remembered it, it was recorded. Whether the witness recorded it himself or someone else recorded it, then we can bring in that prior recording, whether it's a note or a videotape or a transcript, at the trial presently. Now, Rule 803.5 is different than most all the other exceptions under 803. There is an express requirement in 803.5 that the prior recording of the statement or knowledge has to be of a witness. So unlike the other exceptions to hearsay, where we don't care who the person is, the rest of the 803 exceptions make no reference whatsoever to who the declarant is. We've seen it be bystanders. We've seen it be people on a telephone call who were never identified. For something to come in under 803.5, that statement has to have been made previously by a witness, which means the person has to be in court for this particular proceeding. And when it was written down or recorded, that witness had to then have knowledge that witness cannot now recall. Notice what a powerful rule this is. In some ways, this is the flip side of a prior inconsistent statement. So with a prior inconsistent statement, a person can't remember something, and so then we bring in their prior statement. Here, when the person can't remember something, we bring in the prior recording of it. Now, what's interesting about this is that this now comes in as substantive evidence. So you've got a prior inconsistent story under 803.1 that has to be under oath, et cetera, et cetera. To bring it into under that exception, it has to be under oath. Under 803.5, when a witness takes the stand and says, I can't remember this, but I wrote it down. I can't remember this, but I testified to it. Then this is a very powerful rule for getting in those statements. So if a police officer takes the stand and says, you know, I put all this in my report, but it's been 5 years. I don't remember what's in the report. You know, can you read your report and refresh your recollection? And that's another rule that we're going to get to later, writings used to refresh recollections. We're going to get to that rule subsequently, but just know now that that's out there. But if they say, officer, can you read the report and will that refresh your recollection? You know, I see what's in here, but I still don't remember it. Well, officer, when you put this in your report, did you know at the time what had happened? Yes. And does that report reflect, or did that report at the time reflect what your knowledge was then? Yes. At that point, the officer can then read the report, out loud. But the rule, however, says that the report cannot be given to the jury. It can only be read out loud. So in a way, what we're doing is saying, say, for instance, the officer didn't remember the event. We say, if I give you your report, will that refresh your recollection? He reads it and goes, oh, yes, I remember now. It happened on a dark summer's evening. And he continues with the story. But if he can't remember it, what he does is he simply then is allowed to read the report under 805. He picks up the report. It was a dark summer evening in July, and I had just finished my shift. I came around the corner, et cetera, et cetera. So it effectively has the same description for the jury. Both are statements made by a witness on the stand. Neither involves documents that they get to take back to the jury room with them. But this is extraordinarily powerful because those things that a witness now has no recollection of, but wrote down something about before, those previous notes now can come in to the jury. And that's what this case looks at. The defendant objects to the fact that prior trial testimony and prior testimony to the grand jury is allowed to come in as part of the prosecution's case. And the court says, no, that's perfectly fine, because the witness had knowledge and memory of the events at the time of the prior testimony to the grand jury and to in the course of the first trial. Now, the second trial, the witness can't remember, but can testify that when he previously testified to the grand jury and to the first trial, and at the first trial, that he did in fact remember. So those statements can now come in. This is a very broad exception and allows all kinds of statements that we would regard as hearsay and as near misses to 801 D1, D1A, things that would almost make that cut for 801 D1A, prior inconsistent statement, simply not under oath. These statements happen to have been under oath, but what if this was just the police officer's notes or report? That wouldn't satisfy a prior statement under oath at a proceeding and certainly there would be no cross-examination. So you can have a near miss for bringing in these prior statements of a witness that are inconsistent with his inability to remember under 801 D1A, but they'll come in under 803-5, because at the time these contemporaneous records were made of his memory, whether at a trial, whether at a deposition, whether just in his own journal or rough notes from the investigation, those things now become admissible merely because he can't remember. Under 801 D1A, inconsistency is established by not having a memory of the event now and having previously remembered it or known it in the past. Not remembering is inconsistent with remembering under that exception, but that previous prior inconsistent statement under 801 D1A had to be under oath at a trial, deposition, hearing, etc. This is a different way of bringing that stuff in, and doesn't have to meet all the requirements of the other rule.